Hey everyone, welcome to another week of KNR 462. This week we are introducing the topic of tort law, which is an overarching area of the legal system. And we're going to spend the next, I think, 3 or 4 weeks on the topic of tort law. But we're going to break it down by the different types of law that fall under this umbrella. So we're going to start off with the legal concept of negligence. We're going to spend the next 2 weeks talking about negligence. So we've broken it into two different sections. The first one this week is going to focus on really introducing some key terms related to the concept of negligence, kind of going over the basic premise of tort law, and then introducing the specific elements needed to prove negligence in court, and also looking at the different levels of tort liability when it comes to sport organizations. Okay, so before we actually define negligence and get into the legal concepts related to negligence, I want to define the area of tort law. So you can see here we've got this textbook definition of tort law, and that is private or civil wrong or injury suffered by an individual as the result of another person's conduct. So as you can see, based on the definition, tort lawsuits are civil lawsuits, right? An individual has suffered some kind of injury as a result of someone else's actions or conduct, and therefore they're filing a civil lawsuit in order to obtain some kind of damages. So tort law, first and foremost, these tend to be civil cases, not criminal cases, and they tend to be between an individual and another individual, or occasionally between an individual and an organization. So what is the plaintiff seeking in a tort lawsuit? Well, generally speaking, tort lawsuits, from a court's perspective, are an avenue for a plaintiff who's been harmed to basically become financially solvent, right? So if they have lost money because of an injury they've suffered because of someone else's conduct, a tort lawsuit will put them back into that financial standing that they were prior to the incident taking place. That's really the purpose of tort law from the court's perspective. In general, they don't see it as a way for people to just sort of sue anyone they want and get rich overnight. That's not really the purpose of a tort lawsuit. It's really meant to put the plaintiff back into the financial shape they were prior to the incident. So that's kind of a general definition of tort law. And like I said, we're going to be spending the next 3 or 4 weeks here talking about tort law in this umbrella area of the law. If you were in law school, you would spend an entire semester talking about the different areas of law under tort law. Obviously, we don't have that kind of time. So we're just going to focus on 3 primary areas under tort law that I think, and I think others would agree in sport, are probably the most prevalent. And you can see those 3 here on the spectrum that I've provided in the visual here. So on the far left hand of the tort law spectrum, we have negligence, which is going to be our focus this week and next. With negligence cases, there is no intent to act and no intent to harm. And we're going to get into that a little bit more here on the next few slides when we define negligence. But as we look at the different areas of law that fall on the spectrum, keep in mind that negligence is the least severe of the 3. Okay. So I'm going to skip to the right-hand side of the spectrum here, where we have intentional torts. So in an intentional tort case, we have both an intent to act and an intent to harm, right? So intent is present in an intentional tort case. Pretty straightforward. But if negligence is the least severe end of the spectrum, intentional torts are the most severe end of the tort law spectrum. And then right there in the middle, we have what's known as reckless misconduct. In a reckless misconduct case, you have an intent to act, but no intent to harm. So you can see how reckless misconduct falls into this bit of a gray area between negligence and intentional torts. Again, there are examples in the sport industry in all 3 areas, so we are going to spend some time with each. We're going to spend the most time on negligence, as that tends to be one of the more common areas of law that we see present in our industry. All right, so when we looked at the tort law spectrum on the last slide, we said that in a negligence claim, there is no intent to act and no intent to harm. So that's a bit of a preview to our more thorough definition here, which you see is negligence is a failure to use reasonable care that results in harm or risk of harm to another person or party. So in a negligence case, we do not have someone who has intentionally acted to harm another. What we have is a failure to use reasonable care that then results in someone else's harm or some kind of injury to that person. So in a negligence claim, we can either have an act of commission or an act of omission. So an act of commission, meaning someone has taken an action that is negligent, that somehow leads to another person's injury. What is probably more common in the sport industry for negligence claims is an act of omission, right? Basically, someone failed to do a task or fulfill a duty that's required of them in order to provide reasonable care, and therefore that leads to another person being harmed. Really good example of an act of omission type of negligence we can see from this Davidson versus University of North Carolina case from 2001. Give you a little bit of a background on this case. At the time, the University of North Carolina did not have a full-time coach for their JV cheerleading squad. Okay, but they still had this JV cheerleading squad that was expected to practice, cheer at games, travel to games, and basically run as a existing team within the athletic department. During a practice in 2001, one of the girls was participating in a stunt, and the stunt went wrong. She fell from pretty high up to the ground and suffered permanent brain damage as a result of the fall. So, as you can imagine, her family files a lawsuit against the University of North Carolina for negligence. Their claim was that the athletic department's failure to provide a permanent full-time coach to supervise, oversee the JV cheerleading squad, that was a direct cause of their daughter's injuries. That, had there been a coach on staff that was present, that had knowledge and experience in the sport, that injury likely would never have happened. So in that case, we're looking at negligence and specifically an act of omission, right? The university's failure to even provide a coach potentially led to this girl's permanent injuries. You're actually going to get to look at another lawsuit involving a cheerleader later on this semester when you do your first case analysis paper. Involving kind of a similar incident, but involving actually more than one fall. Turns out cheerleading, very dangerous sport if you're not aware. So you'll get to dig a little bit deeper into a similar case later this semester. So when a court looks at a negligence case, they are going to look at the seriousness of the plaintiff's injuries. They're going to look at the scale of potential risk or potential harm associated with the act of negligence. And generally, they're going to classify it using these different levels. Okay, so a slight negligence being the lowest of low, right? Very slight level of negligence occurred, not very serious injuries sustained, that sort of thing. Ordinary negligence just being exactly what it states, right? A typical kind of generic incident of negligence that you would sort of expect. These are the most common. And then instances of gross negligence are when there are essentially willful action taking place, which then kind of crosses into that gray area we were talking about earlier of reckless misconduct. So it's just important to be aware of these different degrees or levels of negligence because the way that cases are classified is likely going to impact the outcome in terms of the damages that are ultimately awarded. And we'll talk more about damages later. Okay, so in a negligence claim, if it moves forward through the court system and goes to court, actually gets to a trial, doesn't get settled like we know many cases ultimately do, but if it actually goes to trial, we have, in this country at least, years of common law precedent surrounding negligence, which means that there have been hundreds, if not thousands upon thousands of negligence cases in this country, which has given us these established elements that a court can then apply to a negligence claim. So when we say elements, it's basically this laundry list of things that have to be proven in order for guilt to be determined in court. And a lot of the different legal issues we look at this semester will have kind of a similar list of elements that we can examine and try to ascertain whether or not we think guilt is present. So in negligence claims, there are 4 elements required in order to prove negligence on the part of the defendant. Those 4 elements are duty, breach of duty, causation, and damages. And as you can see here from this graphic, hopefully, all 4 elements are required in order for there to be negligence in court. Okay, so that means all 4 have to be present in order for a judge to determine someone has been negligent. You can't just have 2, you can't just have 3, all 4 have to be present. Let's talk a little bit about burden of proof in a negligence case. And when we talk about burden of proof, we're essentially determining which party has the burden of proving the case in court, telling the story, making the claim. In a negligence claim, it's the plaintiff. Okay, burden of proof is on the plaintiff to prove all 4 elements in order to prove that negligence exists. A lot of the legal issues we look at are going to have the burden of proof on the plaintiff, not all, but by and large, most of the cases we'll look at or legal issues we'll look at this semester, the burden of proof will fall on the plaintiff to make their claim, prove the elements related to the case. And so as we start to look at each of these elements in more detail, keep in mind that we're viewing this from the plaintiff's perspective today, right? We're looking at how they might go about proving each of these elements in court. So we're really looking at things from the perspective of the plaintiff this week, where next week we'll kind of switch the script a little bit and start to think about things from the defendant's perspective and how they might go about defending themselves in a negligence claim. But for today, we'll focus on it through the lens of the plaintiff. All right, let's just take these one by one and break them down a little bit. First element is duty, okay? So in order to prove negligence exists, a plaintiff has to be able to prove that the defendant, the party they're suing, had an obligation to protect them from unreasonable risk of harm, okay? So basically, plaintiff just has to show that they have some kind of relationship with the defendant that at the time of the injuries occurring meant or dictated that the defendant owed them some kind of obligation to protect them from harm. So you might be thinking, how do we know whether or not someone owes another party some kind of protection? Well, typically there are some specific origins of legal duty in a negligence claim. One is professional duty, right? So a teacher, for instance, by nature of their job title and duties, has an obligation to protect their students from unreasonable risk of harm, right? That's why, when you see K through 12 teachers going through things like tornado drills or even school shooter drills, they're the ones in charge. They're the ones having to explain to the students what to do, and it's ultimately, an obligation on their part to keep them safe from harm. We can see more professional duty examples in other fields as well, right? So, for instance, a stewardess on an airplane would have a professional duty to the people on the plane, right? To keep them or protect them from unreasonable risk of harm should there be some kind of incident where they have to vacate the plane. It would be their job to make sure, the correct things occur in order for the people on the plane to get off the plane. So that's one example. Professional duty is often what a plaintiff would show in order to showcase that the defendant owed them some kind of obligation. In our field, we see this with coaches a lot, right? As a byproduct of being a coach to a student athlete, there is this expectation through that professional duty that that coach would protect those student athletes from unreasonable risk of harm. There can also just be a determination of a special relationship that exists between the plaintiff and the defendant. So, for instance, a parent of a child, the court would deem that to be a special relationship, which means that, the parent has an obligation to protect their children from unreasonable risk of harm. So there are other ways to define this duty, or at least to prove that some kind of obligation is owed. One other example might be in our field, an event manager or a facility manager who is working a sporting event, a live sporting event. And it's, based on their professional duty as an event manager, it's, up to them to make sure that patrons are kept safe from harm when they are at their facility. So that's another example of duty in our field. One question that comes up a lot when we discuss this concept of duty is kind of how do we determine what level of care is expected? Especially when you think about it from your own career perspective, right? How do I know what level of care that I owe my patrons, my customers, fans, whatever it might be? And the answer really comes to us as we examine the next element, breach of duty. So we'll talk a little bit more about that there. Okay, our second element is breach of duty, right? So you might be able to tell just from reading the phrase, but basically breach of duty means that there's a failure to meet the standard of care required based on the duty owed to the plaintiff. So as long as the plaintiff's able to prove that some kind of duty existed, that the defendant owed the plaintiff some obligation to protect them from unreasonable harm, they would next have to prove that there was some breach of duty, right? That the defendant not only had a duty to protect them, but that they breached that duty, right? That they did not follow through and provide that standard of care. I said on the last slide we would talk a little bit more about how we determine that standard of care with this element, and I'll do that now. And essentially, often what a court does in cases of negligence, in order to determine what level of care should have been provided, is they consider this reasonable person standard. So what's a reasonable person standard? Well, basically, a reasonable person is considered someone who would select a course of action that would, be a normal, ordinary, under the same conditions, right? So essentially, think of it like calling an expert witness. So if the court wanted to determine whether or not the defendant acted or provided the level of care that was common for, let's say, a basketball coach for a high school team, they might call to the stand, other basketball coaches of similar age groups, right? And they would find out what would that person do in that similar situation. So that's where this reasonable person standard comes from. It is a little bit more complex than just, asking the person next door what they would have done, although that's certainly helpful in the courtroom. The court would also consider a number of other factors, right? They would look at the risk and what was apparent to the person acting in that situation. They would look at the capacity of the actor to actually respond to or meet that risk. And then they would look at the full circumstances under which that person actually confronted the risk. So it is more complex than just looking at, the next person in the industry and asking them what they would do. But that's sort of how we determine the standard of care, right? The reasonable person standard. What particular path of action would have been selected by an ordinary, prudent person under the same circumstances. And if the standard of care that was provided by the defendant is that level or higher, then great, they're not guilty of negligence. But if the standard of care they provided is much lower or even just a little bit lower, then they were likely breaching their duty. When we talk about breach of duty, I always think it's important to point out that sport practitioners are generally not liable for injuries due to inherent risks. Okay, so what are inherent risks? If you're not familiar with this term, inherent risks are basically risks that are part of the normal, regular activity that you're participating in, right? So if you are participating in football as an activity, you know that there are potential risks associated with getting tackled, getting hit by the player on the other team, right? Those are inherent risks, risks that if you took them out of the activity, then it would no longer be the same activity, right? So generally, the courts are going to look at inherent risks as something that the plaintiff signed up for, right? They knew that these were potential risks when they signed up for the sport activity, and therefore, generally in those cases, the court is not going to hold a sport practitioner liable for negligence. Another thing that the court will consider, and we'll get into this a little bit more later, is this concept of scope of liability or foreseeability. So basically, courts are going to excuse someone from liability in a negligence claim if they deem these instances to be unforeseeable or unavoidable. So, there's a sporting event occurring outside, a lightning strike comes out of nowhere and strikes a fan, right? If there's no weather indicating a storm's coming, this is just a kind of a freak Mother Nature event, then it's very unlikely that a court would determine the event manager, facility manager liable, right? Because that would be something that's unforeseeable. All right, so the third element in a negligence claim is causation. So causation of the four elements is probably the most complex to explain and also apply in court. As you read in your textbook, there are essentially two different levels of causation that the plaintiff has to prove in order to be successful in proving causation. So the first of which is actual causation. So as you can see here, actual causation exists when the breach or the failure to act by the defendant did not meet the standard of care of a professional, but that it was the substantial cause of the injury. Okay, so there has to be a link between the breach of duty and the actual injuries that occurred, right? That's where this causation piece comes in. So you have to be able to link the two in order for there to be negligence. And your textbook uses this phrase, and I think it's helpful for remembering this one, the but-for test. So basically, the particular harm in question in a negligence claim would not have been suffered but for the defendant's negligent act, meaning that the plaintiff has to be able to prove that the actual breach of duty by the defendant was in fact a substantial cause of their injuries, meaning that there couldn't be other factors that played a big role in causing those injuries, but that the defendant's failure to act or their breach of duty was the substantial cause of the injury. So that's actual causation. So if the plaintiff can prove that, then they move on to proving proximate causation. So as you can see, proximate causation is determined by the plaintiff establishing whether or not the harm to the plaintiff was a reasonable, foreseeable consequence of the defendant's act or actions. Okay? So for proximate causation, this concept of foreseeability is in question, right? So if the plaintiff can prove that the defendants would have been able to foresee the consequences of their actions prior to taking the actions, then they can prove causation exists. But if they can't prove that this was a foreseeable consequence of the defendant's actions, then the plaintiff likely doesn't have a case, or at least would struggle to prove causation as a whole. So that's proximate causation. Again, both are really required to prove causation in court. I know that can be a little bit confusing, so I'm going to tell you about an example case, and hopefully that will help you apply this a little bit. So this Bellinger versus Ballston Spa Central School District from 2008 is a great example of a case where all the other elements of negligence were present, but this causation element. So give you a little bit of background here. This was a case that occurred at a school district. It was a PE class for 5th grade girls. And during this particular day of PE, the students went outside. The PE teacher had the girls play flag football. He stepped away from the field where they were playing, went to his office briefly, and while he was away, two of the girls collided on the field and both suffered some head injuries as a result of the collision. So the parents, in this case, decided to sue the school district, right? They basically said, this is negligent supervision. The PE teacher wasn't there monitoring this activity, and therefore, we think that the school district was negligent. So they went to court. The plaintiff, the families were able to prove duty, right? Certainly, this PE teacher has a duty or obligation to keep the students safe from harm based on that professional duty. Was there a breach of duty? Sure, right? He had a duty in particular to supervise this class as part of his job as a PE teacher, and he did breach that duty by going into the office while they were playing. But when they went to prove causation, they ran into some trouble, right? So let's look at both of these types of causation and see how they might be difficult to prove in some cases. So for this particular case, the families were not able to prove actual causation, right? So again, remember, this is the but-for test. So in this case, they would need to show that, but for the PE teacher deciding to leave the field of play, that these injuries still would have been suffered. And the school was able to argue that there was no connection between his breach of duty and the actual injuries in this case, meaning that this collision was such a freak collision that the girls were just playing flag football, running around, that even if he had been there watching, there would have been no way for him to prevent this injury, right? So even though he did breach his duty by leaving the field during that time, they couldn't actually connect the breach of duty to the injuries, right? By applying that but-for test. And the same is true of the proximate causation, right? Basically, because it was such a freak incident, a spontaneous incident that occurred during this flag football game, that there was really no way of him knowing that this was a foreseeable consequence of his actions, right? There was no way to potentially foresee this as something that might happen on the field. And I'm actually going to read you some terminology that comes straight from the case brief from this one. When a spontaneous and unintentional accident happens in just a few moments, we have held that no amount of supervision, however intense, can prevent a resulting injury. So I use that example because I think it's a good example of how it can be very difficult to prove causation. And of the four elements, it probably is the more complex in terms of the plaintiff needing to make their case. And in some cases, it just isn't possible to connect that breach of duty to the actual injury suffered or to prove that there was some kind of reasonable, foreseeable consequence of the defendant's actions. Okay, so the last of the four elements is damages. So this one's pretty straightforward, right? In order to prove negligence occurred, the plaintiff actually has to prove that actual injury or harm was sustained as a result of the defendant's breach of duty. Now, your textbook provides three different categories of injuries. Economic loss, right? Some kind of financial loss. Maybe they had to pay out medical bills. Maybe they lost wages because they had to take off work as a result. Physical pain and suffering, that one's pretty intuitive, right? Some kind of physical pain and suffering that has occurred as a result of the incident. And not all damages have to be physical, right? Someone could have some kind of mental distress as a result of the negligence that occurred, and maybe they're having to deal with some emotional trauma as a result. That can also be considered a category of injury. Last thing I want to mention here on damages is that typically in an ordinary negligence claim, the court is going to be looking at providing compensatory damages to the plaintiff. Compensatory damages are damages that compensate the plaintiff for the actual loss suffered. So whatever it is that they lost as a result of the negligence, they would receive that back in compensatory damages. If the negligence that occurred was considered gross negligence or even reckless, then they might also add on punitive damages. This is going to be additional monetary damages on top of the compensatory in order to kind of make an example and also deter future wrongdoing. Okay, so those are the 4 elements of negligence. We're going to pause here, and in the next video we're going to talk a little bit about who can actually be sued in a negligence claim and also the different levels of liability that provides.